Okay, good afternoon, everyone. Thank you for joining. I'm Michael Ettinger, and this is one of our series of 6 Zoomside chats. Today, we're going to talk about various estate planning topics, second marriage planning, planning for people who don't have children, planning for people who have dependent children and special needs children. As you can see, there's the staff of Ettinger Law Firm. It's our 35th anniversary. We started in 1991. I'm at the top of the picture in the middle. To my left, my lovely wife and law partner, Suzanne Ettinger. And our website is trustlaw.com. Also, ettingerplan.com. It's the same website. As you can see, our practice is limited to trusts and estates, wills and probate, tax saving strategies, mostly estate tax saving strategies, Medicaid applications, Medicaid trusts. We have 12 offices in New York, 2 in Nassau County, Rockville Center, and Lake Success, where I am today. In Suffolk, we have 3 offices. We're in Melville, Islandia, and the village of Huntington, right on Main Street, across the street from Basitos, for people who know the area. Staten Island, 900 South Avenue, the Nicotra Building. Westchester, 140 Grand Street in White Plains. Rockland, we're in New City. And Orange County, we're in Crystal Run in Middletown. Dutchess County, 2 offices, Fishkill and Rhinebeck. And Albany, right there on Wolf Road. There's a feature where you can ask a question. If you have a question, you just type in your question and we'll answer those at the end. Okay, so thank you for joining and let's get started. So second marriage planning, you see from the graphic, just married and then again. Okay, well, sometimes second or third time's the charm. But this makes for complex family relationships because one of them may have children from previous marriage, the other can have children from previous marriage, or they both have children from previous marriage. Not only that, sometimes one or both have children from previous marriage and they have children together. We call those his, hers, and theirs. So these plans, we want them not only to be fair, but to be perceived as fair. So we want the family to feel that it was, there's some logic to how things were done. So, for example, let's say a couple has been married, a fair time, and they have 2 children together, and husband has 1 from a previous marriage. How are you going to leave that estate? Again, they have 2 children together, and husband has 1 from a previous marriage. In a case like that, I say, well, you should divide the estate into 5 parts and give two shares to each of the children from this marriage because they have 2 parents, and give 1 share to the father's son who only takes from 1 parent. So, for example, the 2 children get 40% each. He would get 20%. He takes from 1 parent a share. They take a share from each parent. And I can do that arithmetic pretty much for any family. So that could be explained. Well, they got 2 shares because they took from 2 parents. You got 1 share you took from 1 parent. And remember, he has another parent, the divorced parent, that he's going to get his second share from. So that's one way to do it. But of course, all families are different. Just an example. What are the perils? Well, the big peril is what happens after the first spouse dies. If they have a plan together and the survivor acts alone, they could easily divert all of the assets to their children. Now, you may say, oh no, my husband or wife would never do that. Very honorable person. But even the best intentioned people can be influenced later in life. They could have diminished capacity. All kinds of things happen. I don't have to tell you. So it's not a matter of their character. It's fraught with danger, even with people the best of character. In a case like this, if let's say I'm the husband, I have 2 children. I die first. My second wife is in charge of the estate, how are my children going to feel with my stepmother in charge when she has her own children? Um, and we don't really know what's going to happen there. So we, the children of the deceased spouse, feel very vulnerable and unprotected. And when people feel vulnerable and unprotected, their mind goes to the worst case scenario, and there could be, you know, unpleasantness between the parties because, again, people feel vulnerable, often strike out or acted out. So it turns out sometimes the children of the deceased spouse are hostile to the surviving spouse already, or they become hostile. Maybe the glue, they were very tolerant to the spouse when their father was living, but now their father died. The true feelings come out. And then what if, let's say, they're not feeling that way? Maybe they have a nice relationship, but all of a sudden that step parent gets remarried. Now they're sort of twice removed, and that can create a problem as well. Essentially, it's very easy the family glue to come undone when it's your parent that dies. So how do we address this? Well, um, we could make a child of the surviving spouse, a wife survives, we could make her daughter the co-trustee, but how's that going to help the children of the husband? Um, it is like the wolf watching the chicken coop. So here the estate planning attorney comes in as a possibility. You say, well, when I die, my lawyer is co-trustee with my spouse. So now the children of prior marriage feel secure. They have somebody representing their interests in the matter. They have skin in the game. So the lawyer protects the principal for the heirs and follows the prudent investor rule to make sure that trust fund grows to offset inflation. So what is that prudent investor rule? Well, the guiding principle for a fiduciary or a trustee is to invest as a prudent investor would handling their own affairs. So you have to invest for growth because inflation will cause a portfolio to shrink. And you also have to produce income. So you have to look at how much income the spouse needs and balance the needs for the spouse's income for the need to grow the estate for the benefit of the heirs who are going to get it later on. The nice thing about this is the surviving spouse has privacy. They can do everything with their lawyer. They don't have to deal with the husband's children, who they may or may not get along with, and it's awkward. Um, you know, uh, you don't want the children as the trustees. Another reason is because whatever they spend on the stepmother is coming out of their inheritance, so they have an inherent conflict. So sometimes the lawyer acts in this capacity, and this allows a relationship between the stepmom and the stepkids to keep going and growing. Now, this is just one of the options. All marriages are different, but it gives you some idea of the complexity of planning for a second marriage. What about the beneficiaries? A lot of people have significant sums in their IRA and they want to leave their IRA to their spouse, but it's a second spouse. They don't want to leave it to them because they want to take care of them, but they don't want it to go to their kids afterwards because that's not the intention. Their intention is to take care of their spouse. Their intention is not to take care of their spouse's children. So for this, we've developed an IRA contract. Wife promises, it could be the other way around, but a wife promises that if husband leaves her his IRA, she agrees ahead of time to designate his children as her beneficiaries. It's a contract. And she also agrees that she's not going to take more than the required minimum distribution, except on the consent of the lawyer acting as trustee. The reason for this is because even if she promises to make his kids the beneficiaries, what's to stop her from closing the IRA, take everything out, and pay the taxes on it? Nothing. So she can't take more than her needs without the consent of the lawyer. That's a protection. Now let's move on to another topic, which is planning for those without children. Um, so when we're talking about planning for people who don't have children, we talk more about planning for disability because their disability is more important than who gets it after their death. Whoever's getting it after their death, that inheritance is usually a windfall, not something that they were necessarily expecting or need to support themselves. So when people don't have children, we say, you come first. Who gets it after you're gone comes second. So you're not going to, for example, take the assets and put them into a Medicaid asset protection trust to protect it unless you're unusually close to your nieces or nephews. Most people say, it's my money. I don't have children. I'll use it for myself first. And then whatever I don't spend on myself will go to these people. But they don't like to tie themselves up because it's not their children. So the key question now, if you don't have children, is who do you want to take over if you become disabled? Sometimes we say at Ettinger Law Firm, planning for disability is more important than planning for death, because planning for disability is for you, and planning for death is for somebody else. So this is a key question. Now, the lawyers here at Ettinger Law Firm are willing to do it if you have nobody else, but hopefully you have somebody that would be willing to do that. And with our help, they would have all the tools they need to do the job. Power of attorney, a good one, and prescription strength, elder law power of attorney, health proxy, living will, trust, avoid probate, and having to deal with unnecessary errors, that sort of thing. But if you don't have children, your biggest risk is guardianship. You want to make sure that if you have an accident or illness, the state doesn't appoint a stranger to handle your affairs, because once it gets to that, it's very, very hard to get back control of your affairs. So we want to avoid guardianship. Guardianship occurs if you have an accident or illness, a disability, can't handle your affairs, and you don't have a plan for who takes over. Trusts avoid guardianship. We talk about that in our Four Advantages seminar I'll get to later. But I don't want a guardian. I want the person I pick. And that's what planning for those without children involves. They have to choose somebody as the trustee. So it could be a friend, a relative, and the lawyers co-trustees. These are just some ideas. It could be the friend or relative alone. But on the other hand, two heads are better than one, and they watch each other. It also avoids mistakes, malfeasance, nice word for stealing, really. Mistakes, malfeasance, and third-party interference. For example, you may have picked a friend or relative without knowing that somebody else is bossing them around or controlling them, and that third party is actually running your affairs instead of the person you picked. So the key with the singles and couples without children, the keys there are having the people you want in charge of event of disability, avoiding probate so you don't have to deal with unnecessary heirs. And that is probably the most important thing, is having a plan for disability. Now we get to protecting assets for dependent adult children. So who are we talking about? Well, those who have not been successful in life, this is much more common today, I believe, than it used to be. We have children who just live at home their whole lives, and they just never seem to flourish or cherish. They never leave the coop. There could be immature children or those with an entitlement mentality. I think you know what I'm talking about. They may not be good at handling money, soft touch, or whatever comes into their hands goes immediately out. They could have alcohol or substance abuse issues. They could be learning disabled, and they could be special needs. So all of these require some form of being addressed in the estate plan. So here we're looking at, if we're going to leave an inheritance, who's going to be in charge of it? It could be the child and another family member, or another family member alone. It could be the child and the lawyer. As I said, the other family member and the lawyer alone. Let's look at these. So if you make if you make another family member in charge, there could be resentment because they may have to say no sometimes. The other family member may not want to do it. The child and the lawyer is a possibility because then they have their own lawyer to talk to and reason with. Um, it could be the other family member and the lawyer. Now, this one is used where you want a good cop, bad cop routine. So the family member, well, more than that, but the family member doesn't want to say no, so they let the lawyer be the bad guy and say no. But the family member has more insight into the personal dynamics. The lawyer may have a good handle on the law and the finance, but not know exactly what's going on in the household. So sometimes the other family member and the lawyer is a nice combination, uh, or the lawyer alone if no family member wants to do it. These are just possibilities to be discussed further in a consultation. If you joined us after the introduction, there's a place where you can type in any questions you have, and we'll spend some time answering those at the end. Protecting assets for dependent adult children, delayed distribution. So it doesn't have to be all at once. One of the formulas that has been used is 20, they get 20% at age 30, one half of what's left at 35, and the rest at 40. The theory here is they'll get to 20%, they'll blow it. They have to wait 5 years before they get the next half. And finally, 10 years later, when they have some smarts, they get the last half of the estate. Gives them a chance to get used to having the money. You can do it differently. You could say 20% of my death, one half of what's left after 5 years, the remainder after 10 years. These are just some examples. Now we get to the special needs child. So the special needs trust pays over and above what Social Security and Medicaid pay. And it's important not to go afoul of these rules because if you lose your SSI, you lose the Medicaid, which is attached to it. With these trusts, you can't pay the children directly. And we want to avoid, sometimes parents leave assets to their grandchildren or and that'll knock them off SSI. Or they could have a brother or sister dies without a will, and then they get a share as a sibling. And again, they lose the SSI. So you have to be careful about other family members and making sure these sort of things don't happen. But there are two kinds of special needs trusts, the first party versus the third party. So want to avoid overcompensating. I think it was Ben Franklin who said, the tongue is always turning to the aching tooth. All the attention goes to the special needs child, and this can create social problems with other family members. So we want to avoid that. The estate doesn't have to be equal. Sometimes, there's not going to be enough assets to take care of the special needs child and to give everybody an equal share. And in those cases, I suggest to the parents to talk to their other children and say, look, little Mary is going to need a lot more help. And we'd rather leave enough for her. And if she doesn't need it, you'll get it back. Then leave everything equal and she runs out of money and you have to go into your pocket and give back. I believe that people would rather not get than get and have to give back, especially after they spent it. So you may have to leave an estate unequal. For this, or to avoid this problem, sometimes people go for second to die insurance. Second to die insurance is also called survivorship life. It's a life insurance policy over two people's lives, in this case, the parents. So they're both insured, but the policy only pays when the second one dies, which means the premium is lower because the insurance company doesn't have to pay until two lives are over. So that brings down the premium. And also, it's very good for this purpose because it's when the second parent dies that we need to provide for the special needs child. So sometimes the second to die insurance can make up for the shortfall in the assets to make sure there's enough to take care of the special needs child, and we can still leave an equal share of the other assets to the other children. We suggest with a special needs child You leave something called a letter of intent. You can look this up on the internet, but this is for somebody who will have to take care of your special needs child one day. What are the daily medical needs? What are their routines? What are their likes and dislikes, their hot buttons? Make it easy for somebody to get to know them and deal with them by giving them a guide to what they are like and what's going to work and what's not going to work. Here's a list of the extra needs of a special needs child that special needs trust can pay for. Can pay for clothing, essential dietary needs, education, hobbies, sports, exercise, tickets for events, health costs. Remember, it's paid directly, right? From the trust to these providers, healthcare costs, medical procedures, vocational rehab, household goods, personal care products, personal services, maintaining the home, music, real estate, car, transport, vacations, burial costs. Not a comprehensive list, but pretty extensive. Let's talk about estate taxes for larger estates. Maybe this doesn't apply to anybody, or maybe it does. But the exemption today in New York is 7,160,000. So everybody knows the federal tax, 14, 15 million, but not many people know that New York has an estate tax. It starts at 7,160,000. So let's say you have a $7.5 million estate, you're over the limit. Once you go over the limit, they tax the whole estate. You owe over 600,000 in taxes. If you have a spouse, the way to avoid this is if you have a spouse, instead of two trusts, you can double the estate tax exemption from 7 to over 14. Then you probably don't have a problem. Your tax savings starts at 600, goes up to well over $1 million, depending on the size of your estate. So you do have an estate tax problem if this is you. I give a seminar. The next one is after Labor Day on the 4 advantages of using trust. And there I talk about avoiding guardianship, avoiding probate, Medicaid asset protection trust, and the inheritance protection trust, keeping your assets in the bloodline and protecting your heirs if they get divorced or sued, protecting your assets in long-term care, how to qualify for home care or facility care. Again, whenever you register for an Ettinger seminar, you get the recording afterwards. So if you can't make it, doesn't matter. Just register and you'll get the recording. I've been giving this talk for, well, over 35 years. So it's pretty distilled, very, very clear. I think if you haven't seen it, you might find it valuable. There's my new book, 2025 edition, Ettinger Law Firm's Guide to Protecting Your Future. Very comprehensive. But we have a unique planning process. It's begun with this seminar. We offer a no-cost initial consultation where you get all your questions answered right from the get-go. We're going to do a complimentary review of your existing plan if you have one. Bring in your documents, will trust. Generally, they're obsolete, but if you want us to look at them, we will. We'll give you a free copy of our book, Ettinger Law Firm's Guide to Protecting Your Future, and we'll tell you which chapters to read that apply to your situation. And we'll also tell you how much, what we're recommending and how much it will cost. This is right in the first meeting. Then we're going to ask you to come in for a second no-cost consultation a couple weeks later to answer any questions you have about what you read in the book and any questions that came up from the first consultation. And now we'll draft the estate plan together with you. Who do you want for medical, first choice, second choice? Who do you want to handle legal and financial? One person or more than one person, that sort of thing. And at the end of that second meeting, you get a detailed written proposal for the fees quoted. So the fees are the same we told you first time verbally, but now it's all in writing. And now the choice to go ahead, of course, is up to you. And unique among law firms, I believe, in the country, we do not have a retainer agreement. You don't sign anything. You don't pay any fees. Why do we do that? We just, based on your say-so, we're going to go ahead and prepare all the documents. After you come in the third time and review everything, you pay at the end. The reason we do that is because I had an epiphany, I guess you could say, certainly more than 10 years ago, that when a client gives a lawyer the retainer, the client actually loses control because the client doesn't have anything except a promise, has to hope the lawyer delivers and that the client will be satisfied. So it's a loss of control by the client. Well, I'm very big on putting the client in control. So, um, that's what we do with our power of attorney, our estate planning, our uh, our trusts are all designed to give you control over your affairs. So it didn't make sense to me then. What lawyers, the way I was trained, is the first thing that happens when the client comes in is we take the control away. So you're in control of the situation here until the end. In fact, until you sign, you don't owe us anything. So you come into that final meeting, we review all the documents, everything gets signed, and you can pay by credit card or check. People usually pay by check because now we have to charge the 3% for the credit card. And you can pay it all at once, or you could do it in 3 monthly installments. Unlike the most of the profession, we don't say goodbye, we say welcome to the firm. So the standard in New York is thank you very much, goodbye. In fact, I was at a CLE, continuing legal education, and they had so-called experts. They had defense counsel, they had elder law counsel, they had ethics counsel, and the panel said after you sign your estate plan, we should send you a letter thanking you for your patronage and advising you that this concludes our representation of you. And the reason they say to send the letter is in case you made a mistake after a few years, they can't sue you because the statute of limitations runs from the date of that letter. Essentially, and this is the way lawyers are taught in this state, and something I don't agree with, the lawyers are worried about the 1 in 10,000 clients who's going to sue them. We, however, are more concerned about the 9,999 clients that aren't going to sue us. So we ignore that advice. We think it doesn't suit us. It basically says that the estate planning is a transaction. It's not a transaction, it's a relationship. We hope for it to go the rest of your lives and beyond. So we don't say goodbye, we say welcome to the firm. We're not worried if somebody's going to sue us one day. We're insured for that. Nobody's perfect, but uh, we're worried about the 9,999 are going to need us. So we have a trademark process. We keep you up to date of any law changes because we publish a law letter once a week. It comes by email. So we call it the Ettinger Elder Alert. Every 3 years, we call you in for a free review. See if there's any change in your health, your assets, your family, births, deaths, marriages, divorces. We never charge for phone calls or emails or questions because we want people to feel free. And the fact is, by using this program, your plan is never more than 3 years old, which means what? It's designed to work when you need it, hopefully some decades later, not when you signed it. So we believe pretty firmly, 35 years at it, it's a better mousetrap. Certainly our clients feel that because they very much appreciated this monitoring maintenance. And, it's more satisfying. We build up relationships with our clients because we see them regularly. And when something happens, we're there. So now I'm going to invite you at your leisure to schedule a no-cost consultation with myself, my wife and law partner, Suzanne, one of our other experienced elder law estate planning attorneys, where you happen to be. Everybody is vetted. Everybody does the same work, no matter who you speak to. But you'll pick that. I myself am available in Staten Island and Lake Success, Rockville Center, Huntington, and if I didn't mention it, White Plains. We prefer the office because there's a lot to be gained by a face-to-face meeting, but we can do it by Zoom or by phone if that doesn't work for you. I just call the toll-free number and the prompts will set you up to schedule a no-cost consultation or visit us. You can do it right at the website at trustlaw.com. Okay, so let's see if we have any questions here. Uh, okay. I don't see any, but you never know. Okay, some were sent in. Um, one, Diane J says, are we experienced with same-sex marriages? Yes. Those without children? Yes. Are there unique issues that need to be addressed? I would say no, not these days, but it's very useful to have a plan. Um, Darlene F says, if I put my home in a Medicaid trust and buy another home, but take a partial mortgage on it, can I sell the home in the Medicaid trust and use some of the proceeds to pay off the mortgage on the new home? If I also put this new home in the trust, the answer to that is yes. If they're both in the trust, you can move assets from one trust asset to another. Um, let's see what else we have. Okay. Um, Lisa D says, do bank accounts go into the trust? Well, it depends if it's revocable, irrevocable. Bank accounts, if they're significant, they should go into the trust because then somebody could take over if you become disabled. But the key is if the bank account is not in the trust, it should be joint or have a beneficiary so that there's no probate on the death of the account holder. Ken N says, um, and a 403B, like it's an IRA, 401k, 403B, all those deferred to age 73, can they put into a trust? No. If you take those out of your name and put into the trust, that's a taxable event. You would owe all the tax. We want to avoid that. So no, we're not going to do that. Um, you should know that, oh, there's the questions. Okay, good, I found them. You should know that IRA, 401k, 403B are exempt from Medicaid. They can't go after your retirement account, and they're exempt from probate because they have a designated beneficiary. So no reason to put those into the trust at all. Now, we have a few questions from Anonymous says, hi, I need assistance with knowing what estate planning entails and help with a living will. So, Anonymous, I'm glad you asked that question. You know, um, estate planning is something that very few people have confidence in. So most people, when they come in to see me, I tell them right away, I know your confidence is low because everybody who comes in has low confidence because they don't know enough about estate planning. So we designed our practice to build your confidence. We believe it's a confidence building exercise. That's why I give you a copy of my book, which is written in plain English, and tell you which chapters you should read. I have a 37-minute video on the website entitled "For Advantages of Using Trust." It covers everything you need to know. So we take our time with those two consultations, and you're doing the reading and watching the video to build your confidence, get all your questions answered so that you're prepared to go forward. Anonymous says, should a married couple create two separate wills or trusts? Well, no, because generally they want to they keep their assets together so they can use one trust. The trust says they're both in charge. It's like a joint account. And if one dies or becomes disabled, the other one acts alone. And if the second one dies or becomes disabled, then you decide who you want in charge. On the other hand, if the estate is over 7 million, you need two trusts to save the estate tax. William B says, do you help people live out of state? I can't do a plan for somebody who lives out of state, but I'm going to ask you to, if you're have a pen and paper handy, for out of state, you would go to the website of the National Academy of Elder Law Attorneys, and that website is naela.org, naela.org. And then you can search by zip code for an attorney in the area where you are. You can scroll out within 5 miles, within 10 miles, within 25 miles. It's very good. Now, if you're looking for an attorney, I recommend first you look at their websites, do your due diligence. You can learn a lot from the website, and then pick the two you think are the most qualified based on your research. Interview two, and you're bound to like one better than the other, and that's how you find an elder law attorney. Regina B says, I would like to schedule an in-person consultation. Well, that's good, Regina. I prefer in person because it's more personable. Um, I want to fully understand what a trust is, and I also want a living will. And I just explained, Regina, we're going to take our time and make sure you fully understand it because I have an expression. I like to say, if you don't understand the plan, you don't have a plan. So we're going to make sure you understand it, you're comfortable, all your questions are answered, and it's worked very well for our clients over the years. So there we go. I want to thank you. Everybody stayed right through the end. It's very nice. I enjoy doing this, and I appreciate your attendance. And Regina, you thank me. Thank you. You're welcome. So let me wish everybody good afternoon. Enjoy the rest of the summer. It looks like we have a hot week. It's nice to get another warm week. Kind of like pushing summer, extending it. So enjoy the weather, and we'll see you next time. Thank you.